All right, good morning everybody in the UK, good afternoon and evening everybody in China, and hello everyone in between. You're very welcome this morning to our IP Trademarks webinar. I'm delighted to have Tom Duke and Lindsay Lowe as expert speakers. Before we begin, I'd like to just do a little bit of an introduction of CBBC for those of you who don't know who we are. The China Britain Business Council is the leading organisation helping UK companies grow and develop their business with China. CBBC supports British companies of all sizes and at every stage of market entry with practical in-market assistance, services, industry initiatives, as well as a membership program offering access, seminars and significant networking. CBBC works closely with UKTI and the FCO and has strategic partnership with the British Chamber of Commerce in Beijing, providing corporate members with reciprocal membership. Our business-led board and professional team have extensive first-hand experience of doing business in China, and through 60 years of engagement, CBBC has built up exceptional connections with government and business across China. CBBC services are delivered through a network of 10 offices in the UK and 13 strategic locations across China. CBBC helps companies to network and learn from China-savvy multinationals and SMEs, to understand the intricacies of doing business in China, and to develop sound strategies for expanding in the fast-changing and dynamic marketplace that is modern China. So that's just a little bit of background about ourselves. You can see that we have quite a large coverage. We've recently, just last year, opened up offices in Xi'an and Changsha, and CBBC is indeed going through a large development, restructuring, and is indeed growing and adding up to 20 headcount in China and the UK. So we're definitely a lead organization for you facilitating your business with China, and please feel free to contact us. All right, so our webinar today is pretty interactive. What I would ask is that if you have a question, please type it in. You can see that I'm highlighting the zone there with the red blob. I'm highlighting that area. If you've got a question, if there's a technical difficulty, or if you just want to ask the speaker a question, please ask. If your question is pertinent to the flow of what the speaker is discussing, I'll drop it in there and then. Otherwise, I'll hold it to the end. And failing that, if we don't get it to it on the day, I'll ask the speakers to follow up with you afterwards. If I could ask you, please, if everybody could click on the raise your hand button. If you could just click on the raise your hand button. And that will just, you can see I'm highlighting it here. That will just enable me to know that you can hear me, basically. Brilliant. So I can see lots of little hands waving at me. Okay, well, thank you very much for that. So moving swiftly along. Just one more thing, how can CBBC help? CBBC has recently launched a trademark request for proposal service. This can be used to quickly and easily gain like-for-like quotes from service providers for registration of your brand. CBBC's IP team is happy to answer your queries relating to translating your name and registering your brand in China. So if you have any interest in this or want to be included in any way, please contact ipr@cbbc.org. All right, fantastic. So we have two speakers today. As I said, Tom Duke. I'll just briefly introduce Tom. Tom has been the UK's intellectual property attaché to China since December 2011, based in the British Embassy in Beijing. Tom is part of the UK Intellectual Property Office's International IP Attaché network, which includes attaché postings to New Delhi in India and Brasilia in Brazil. I'll keep us moving along today. We have a lot to get through. Lindsay Lowe is a legal advisor with the Scotch Whisky Association. So Lindsay is a member of the Legal Affairs Department of the Scotch Whisky Association, which is the trade association of the Scotch whisky industry. His primary role is to protect the geographical indication Scotch whisky from unfair competition, and is responsible for the association's legal work in the United Kingdom, France, Spain, Italy, South Africa, China and Taiwan. Just that area, as well as a number of other small markets. So we're delighted to have both our speakers. Before we begin, as I said, this is a relatively interactive session. So I'd just like to ask everybody a question, please. I'd like to launch a poll here and just ask you simply where you are. So if you could please just click on exactly where you are. I think it gives us an idea of who we're talking to. One of the things that we've used this platform for is to bring content and information to people who mightn't be based in London or Beijing or Shanghai, but who still work very, very closely with China. So it's important for us to bring everybody as much relevant and important work information as we can. So I can see that pretty much everybody has voted. So I'll just close that, and I will share the results with you. So as I said, 57% UK outside London. I think that's really encouraging for us. The whole idea of this platform is to give information to people who mightn't necessarily have traveled an hour or two for this event. All right, terrific. Right, I think that's enough from me this morning. I'm going to just check in with our speakers again. Tom, are you out there?
Yes, I am, David, yes.
Great, Tom. Over to yourself with your trademarks in China slide. And let me just check in that Lindsay is there also. Lindsay, are you with us?
I'm with you.
Brilliant. Okay, over to you, Tom.
Okay, thank you very much, David. Hello, everybody. Thanks for joining us on this webinar. As David said, my name is Tom Duke. I'm the UK's IP Attaché to China, based in the British Embassy here in Beijing. My role here at the start of this webinar is to quickly frame our subsequent discussion, which will cover Scotch Whisky Association engagement with the Chinese trademark system, and then moving on to some of the key elements of the Chinese trademark law, which are being changed, and the changes will come into force from May 2014, so very soon. So you can see on the slide there I have some sort of basics of overview and some facts about the trademarks in China. One of the key points to pull out is that the Chinese intellectual property system has developed a long way and developed very, very quickly since the first modern trademark law was enacted in China back in 1983. You can see that there were almost 2 million trademark applications made to the Chinese Trademark Office in 2013, and that is a different order of magnitude to any other office around the world, including the OHIM office, which covers the whole of the European Union. So there really are a very, very large number of applications, and over 90% of those applications for trademark protection in China are coming from Chinese companies. So Chinese companies, Chinese individuals are increasingly comfortable and familiar with intellectual property systems and are using them. Our message to British companies that are using the Chinese system is generally fairly upbeat. Now, the system is by no means perfect, but we're at a stage now, a stage of China's development, where most companies can achieve good outcomes from the Chinese system most of the time. And indeed, many British companies are using the Chinese trademark system on a daily basis, and there were over 7,000 trademark applications in China by UK residents, so by companies or individuals, in China last year, and indeed we've been running at that level for the past few years now. So many Chinese companies are using the Chinese trademark system, either engaging directly in applications here in China or going through the international application system. So basically using their application in the UK or Europe first, and then extending it on for protection elsewhere. So the Chinese system is big. It's being used a lot by Chinese companies, but also by British companies. Before handing over to Lindsay, I wanted to highlight the sort of 3 main questions that we hear from British companies about trademarks in China here in the embassy. One of our roles is to provide support to companies who are doing business in market or who would benefit from some additional support from the British government in China. So we have a fairly good vantage point to understand some of the key questions that are raised with us. So I'm just going to outline the main 3. The first one is, how do you apply for a trademark in China? It can depend a little bit, so what sort of application you want depending on your products, but you can either go, and it's most common to go through your UK trademark attorney or your UK legal representative, or if you prefer, you can indeed engage directly with Chinese attorneys, but you need to engage with some sort of intermediary in order to get your mark in China. The second question, and I think we'll touch on this both in Lindsay's presentation but also in the discussion afterwards, is we hear from companies who are tackling preemptive registrations or bad faith applications by third parties for their mark that they own in other countries in China. This is unfortunately a fairly common problem for companies in China that we see on a fairly regular basis, and I say we can talk about some of the ways that people can try to combat that, both under the current system and the new system, which will come into force in May. But of course, the main and sort of really fail-safe way to guard against that is to get in there first and apply for your mark as early as possible. And then finally, the third point that we have raised with us are questions about how to enforce trademarks in China, so how to combat infringements of your trademark. On the screen there you see some of the main options, but we can maybe discuss that a bit more in the discussion session at the end after listening to Lindsay's examples of him engaging with these parts of the system on behalf of the Scotch Whisky Association and its members. So that's it from me for now. Over to you, Lindsay.
Well, thank you very much, and good morning. Could I get my first slide, please?
Absolutely. Actually, I think before your first slide, Lindsay, we have a quick poll. How many licensed Scotch whisky distilleries are there? So just for people who may not know the extent and range of the organization that Lindsay works for, I'm just going to launch that poll. Maybe click on one of the options there. Are there 17, 47, 89, or 109? Let's see if people know a little bit about your work, Lindsay. Just give it another couple of seconds. All right, just out of interest, so I'll close that off and I will share the answers with you. So nobody thinks there's 17, 18% of you think there's 47, 46% of you think there's 89, and 36% of you think there's 109. Lindsay, I'll hand over to you and let you answer the question and introduce your organization.
Well, I'm very pleased to say we have 109 working distilleries in Scotland at the moment, so the industry's in good health. Well, thank you very much, and good morning or good evening. What I'd like to do is first give a short introduction to Scotch Whisky and the Scotch Whisky Association, and secondly, explain how we use the Chinese system to protect our product, and finally, let you have my own impressions of the Chinese system and show some of the lessons that I've learned over the past 10 years or so. So if I could have my next slide, please. Scotch whisky's been made in Scotland for over 500 years, and originally distillation began as a way for farmers to use up their excess barley. But from quite humble beginnings, it's grown into a global industry. Annual sales exceed £4 billion, and exports represent the equivalent of 40 bottles leaving Scotland every second. Scotch is a geographical indication of origin and can only be made and matured in Scotland, but that's only the start. It must also be produced according to a strict legal definition. Amongst other things, all Scotch must be aged for a minimum period of 3 years in oak barrels, and some much for longer times. In China, the standard age is 12 years. This is very important in developing the aroma and flavor, but it's also very expensive. So what we have is a desirable product that's expensive to produce, which unfortunately means that there is a great incentive for those to pass off fake inferior spirits as the real thing. So could I have the next slide? Unlike brand counterfeiting, which affects specific companies, protection of the geographical indication Scotch whisky is an industry-wide issue and is the responsibility of the Scotch Whisky Association. The association, based in Edinburgh, is a limited company funded by its 56 members who make up around 90% of the Scotch whisky industry. Our mission is to protect and promote Scotch whisky, and we work in a wide range of areas for the industry, removing barriers to trade, environmental strategy, alcohol and health, but one of the most important areas is legal protection. I'm one of 5 lawyers, assisted by a paralegal and 3 support staff, who are employed full-time by the association to conduct this work. We are very fortunate that the Scotch whisky distillers are prepared to invest to this degree in the protection of their product. Now, an important part of our work relates to trademark protection in China, and I'll now go on to explain more about this in detail. So go to the next slide. First of all, we're trademark owners, as we've registered Scotch whisky and its Chinese translation as collective marks. This means that no one can use these words on a product unless it is genuine Scotch whisky produced in Scotland. We found it quite a straightforward process to register, although it did take quite a long time to complete. And I cannot emphasize enough how important it is to protect your brand as a trademark in China. First of all, it puts a very useful marker down. When we started our work in China, it became apparent that many companies thought Scotch was simply a generic term for good whisky, And when they learned that it had been registered, many backed away from making fake products. Secondly, it makes protection of your brand so much easier. And finally, if you don't register your trademark, someone else will. So we go to the next slide, please. Next, we oppose marks. Our concerns are slightly different from the normal trademark owner because in addition to looking out for trademarks that infringe our own, we also oppose Scottish-sounding marks to prevent them from being registered for Chinese spirits, as these may then appear on fake scotches. Here are two examples of marks we successfully opposed: Scotia, which is an old name for Scotland, and Islay Crown. As some of you may know, Islay is an island off the west coast of Scotland with 8 distilleries famous for their peaty flavours. So far, we've opposed around 100 applications, and increasingly we are obtaining favourable decisions, particularly from the second-tier body, the Trademark Review and Adjudication Board. Moving on, if I could get the next slide. And the third element is protecting our brand, and taking action against those selling fake Scotch whisky. Most often, we use the administrative route, which involves filing a complaint with the Administration of Industry and Commerce in the locality where the counterfeiter is based. But in more serious cases, we have resorted to criminal action, and in addition, we are now preparing our first civil case before the Chinese courts. The picture shows the moment when the Chinese authorities raided a Scotch whisky factory in Fujian province. Now, although it appears a ramshackle operation, we later discovered that there was enough packaging in that room to make 99,000 bottles of fake Scotch. Well, fortunately, the AIC upheld our case, ruled our trademark had been infringed, and shut down the operation. One of the strengths of the Chinese system is this level of administrative enforcement. That's what we do. I'd now like to go on and say what we've learned about the system. I could get the next slide.
Yes, and if anybody has any questions, please feel free to type them in. I've had a couple already, but if there's any issues on your mind, please do ask a question.
Great. We are users of trademark systems across the world, and our experience is that there's much to recommend what the Chinese have to offer. First of all, the system is simple and streamlined. It operates using fairly brief written submissions, and unlike many other countries, there is no need for lengthy affidavits or for your evidence to be stamped by the Foreign and Commonwealth Office and legalized by foreign embassies. This is reflected in the fact that the cost of registering or opposing a mark in China is comparatively cheap in relation to other jurisdictions. Not only that, but we find that in an international level, trademark agents and lawyers charge quite competitively. Although it still takes a long time for things to happen, decisions are coming through much more quickly. When I started dealing with the system, it took about 2 to 3 years for an opposed trademark application to be dealt with. Now we're finding it's closer to 1 year. And most importantly, we find that the Chinese system of administrative enforcement is efficient and is also free to use to the brand owner. You only have to pay your own lawyer's fees. In most occasions, we find it matches or even exceeds what is in offer in the European Union. So could I move on, please? There is, however, as in any country, some room for improvement. There are a lack of reasoned decisions. They can sometimes be so brief as to be meaningless, particularly at first instance. And this is perhaps as a result of Chinese efforts to deal with a large backlog of trademark applications. We also find there's quite a... sorry, David, I think you've gone forward a slide. There's also a lack of transparency. For long periods of time, you don't know what's happening. You may not know how the other side has responded to your arguments, or even if your mark is being opposed. There's no precedent system in China, which can lead to inconsistent results in similar cases. Trademark examiners don't follow decisions in earlier cases. This can be frustrating and can cause a bit of additional work. As Tom mentioned, bad faith applications are a big problem. And this is where a customer or a business partner or even someone who's just seen your brand on the internet tries to hijack it by registering a similar mark or the same mark themselves. These are very difficult to deal with under the existing system, particularly where someone registers a mark the same as yours but for a different type of goods. A typical example in our industry is where someone will take a Scotch whisky brand and register it for clothing. And finally, the trademark system at the moment does not encourage settlement. Perhaps this is more the attitude of some Chinese agents in the law, but when, for example, we've proposed a coexistence agreement to resolve a matter, it's either ignored or met with an unreasonable demand for money. It's also very difficult to amend or adjust applications once they've been filed to facilitate settlement. Increasingly, Western systems are focusing on early settlement, and it would be great to see the Chinese following this path also. Could I get the next slide, please?
Sure. Excuse my going back and forth on that. I have a
No problem. No problem.
Lindsay, I have a quick question here from Nikki. How do you operate your trademark watching system in China, for instance, for conflicting published applications?
Well, that's a very important point, and I was going to mention it in the next slide, but I'll mention it now. We subscribe to a trademark watching service, and it is a very, very valuable tool. It lets us know what's happening in the market. It provides us with intelligence. Quite often it leads to investigations where we can find people making fake Scotch whisky. And sometimes it leads to us taking out a preemptive strike, getting the trademark opposed, and stopping someone getting into the business in the first place. A lot of trademark agents offer this service, and it's worth discussing with your trademark agent. It can be quite daunting in China because, as Tom said, the volume of applications is huge, and it does take quite a while to rake through all the relevant or possibly infringing applications. But it's certainly something worth spending the time and money on, and it really is fundamental to our work in China.
All right, thanks very much for that. I'll let you continue on.
Right, so the lessons we've learned. First of all, and Tom's already said this, register your mark early, because if you don't register it, someone else will do it. Sometimes it's an opportunist third party, but on many occasions we've seen a brand owner's own customer or business partner do it to protect their own business interests. Once the application's been filed, it's very difficult to sort out and can damage relations with your Chinese partners irreparably. Secondly, choose a good Chinese name and register it too. This may be very important because your customers will not all read or speak English. And get local colleagues or contacts to review it to make sure it sounds appealing in Chinese and has no second unexpected meanings. Thirdly, I've already said, subscribe to a good watching service. This really is key. Fourth, if you oppose a trademark, take the process seriously. For example, if you need to show that your mark is being used in China, see if you can produce magazine articles or advertisements or even a picture of your stand at a trade show to show how your mark is being exposed to Chinese consumers. Many cases are lost simply because the person opposing has provided too little relevant evidence. Fifthly, the Chinese are beginning to take IP enforcement very seriously. The Administration of Industry and Commerce in particular are on the lookout for cases they can take. It makes them look good. It helps them meet their targets. So it's really important you build a relationship with them and work with them. If you can get out to China and visit the authorities in any areas that you're having problems with trademark infringement, that is incredibly valuable. If you can provide training to let people know how to identify fake goods that are using your trademarks, again, that's ideal. And something the ICA also appreciate is simply a thank you. or a small gift after a successful infringement action. We've got into the habit of providing small plaques just saying thank you and expressing our partnership with the organizations we've worked with, and these go up in the wall, and they're seen as a great token of respect. So the next time you need to go and get help, they're more than willing to listen to you. A couple of other points. I don't know if I put them on my slide, but one of the strengths that we've had is that we are part of an organization where our members work together. That can be very efficient. It can save costs, and sometimes the Chinese authorities are more comfortable dealing with an industry association than a direct commercial company. So if there's an industry association you can join to help you with your work in China, I'd recommend you do so. If there's not one for your industry, perhaps consider set one up. And then I think perhaps the last point I'd leave you with is that I'm not sure who's listening, but perhaps many of you are thinking, well, it's okay for the Scotch whisky industry. They're big, they're rich, they've got lots of money, and we are very fortunate in that regard. But I think the message I'd leave is don't despair in China. Don't think it's all too much. I can't do anything to protect my brand. It's really important to do what you can, to register the marks you can afford to do so, to monitor as best you can, and any efforts you make in that field will be greatly rewarded. So that's my thoughts, and thank you very much.
Thanks very much, Lindsay. Just there's a couple of questions that have come in on a similar theme, and one in particular from Fred, and he asks, what are your thoughts about creating a mark based on Chinese characters rather than on a standard global mark? I think in Fred's circumstance he's had some difficulty whereby some aspects of it have been declined by the IP office. So just that general area about approaching Chinese marks, Chinese language marks.
Well, I think one thing that we found difficult to understand is that I think Chinese characters can be more loosely defined. Tom might help me out here, but we found that getting a Western meaning to Chinese characters can be quite tricky. I understand a number of companies have done very well. They've managed to get a good expression of their brand in Chinese characters. But I think it's really important that you get somebody who's in the market or do consumer research to give you their feedback. Because there are a whole list of stories of big companies, I think, that have come unstuck by adopting Chinese characters that haven't met quite what they mean. So I think it's an excellent idea, but local research is imperative.
Thanks. Tom, have you a comment there?
I do, and I completely agree with what Lindsay says. We spoke with several companies, a number of companies about this over the past couple of years. So getting some local knowledge and some advice on how to choose a Chinese name or a Chinese mark to register is very important. You normally have a few different choices. So you could either go for something that's a sort of phonetic sort of translation, which is quite close to the sound of your name or your international mark, or you could choose something which is not quite as close phonetically, but that has some sort of auspicious meaning. It's also worth bearing in mind that we've often seen in China with Chinese consumers that if you're quite late in making a Chinese name for your product and registering it as a trademark, you may find that your consumers have already given you a Chinese name. So it's worth also scouring the Chinese internet and looking on, well, a few years ago it was on internet chat rooms or on the social networking sites now to see whether people have already given you a Chinese name for your business that you might not be aware of.
All right, thanks very much. Lindsay, any other closing words from your side before I hand back across to Tom?
I think I would just leave with a message that the Chinese increasingly are taking IP enforcement very seriously. There's a lot you can do to protect yourself in China, and that your efforts will be repaid greatly.
Okay, thanks very much. Yeah, I think even at CBBC, just speaking from our side, there is a clear progress in this area, and it's one of those sort of, dark areas that people unfamiliar with China lack a lot of confidence in and feel that there's, it's only doom and gloom. But I think while there are still many issues to confront and many different regulations that need to be either written or enforced, I think there's clear progress, and I think that segues nicely across to Tom. Tom, before we go to you again, you have a poll for everybody. Now, this poll is just to understand where everybody is in terms of trademarks in China. So it just asks which of the following best describes your trademark situation in China. So if you could just click on the answer, this will just give Tom an understanding of who's out there, who we're listening to today. So just click on you haven't yet applied for, you have applied for, I mean, you have a fully registered one, or perhaps your experienced bad faith application at the minute, or maybe you're a service provider, perhaps a law firm or other consulting firm. So just give us an understanding of who's online today. You're still out there, Tom?
I am, yes. So whilst those results are coming in, please do jump back in, David, when you have them. But I think Lindsay's given out some really good advice for people there on protecting and enforcing IP in China. There really is value in getting involved, register your mark, apply to register your mark. If you have a mark and you spot an infringement, there are a variety of channels you can take to enforce against that. And so get involved, speak to your lawyer, and work out what can be done, because you can get results. And there are also some great lessons there for industry associations.
Okay.
I know not every group is exactly the same as the Scotch Whisky Association, but if you are listening from an industry representative body, please do feel free to get in touch, and we can talk a bit about how you could take action on behalf of your industry or membership.
All right, Tom, just to give you a little bit of feedback, the 51% are representing an industry group or professional services organization, 18% experiencing bad faith applications at the minute, 18% have also applied or fully registered a trademark, and 13% not yet. So principally we're dealing a lot with industry group and professional services online today. All right, so I'll hand back across.
Great.
Your slide is up there, implementation of the revised Chinese Trademark Law.
Okay, great. So what I'll do now is very quickly pick out some of the main things that companies should be aware of or make themselves aware of around the implementation of the revised trademark law from May the 1st this year. So only a few weeks to go until the new system comes into place. How I'd like to frame this, particularly from a company point of view and an industry association point of view, is what are the sort of questions that you would be asking your lawyers, or if you are indeed a trademark attorney, what are the kind of things that people might be asking you and that you should be preparing yourself for. So as the slide outlines, this has been quite a long process, and actually a fairly transparent process. This revision dates back to around about 2005. So it's been quite a long road to get to this point, but the National People's Congress, the legislature in China, passed this revised law in the end of August last year. So some of the things to watch out for from May the 1st. As we've heard, bad faith applications or alleged bad faith applications are one of the most common problems experienced by British companies in China. Of the sort of non-industry groups or professional service providers that are attending today, we see that it's more than a third of people here have or are experiencing this at the moment. The new law does include provisions. Doesn't say that bad faith applications are not allowed, but it does say something which we believe will be very similar. It says that applications should be made in good faith. As always with new regulations, it's difficult to see exactly how this will be applied, but on the face of it, it does look like efforts are being taken to protect legitimate businesses from bad faith efforts to preemptively register marks. So one of the things after May 1st, and the time goes on and we see how this new provision unfolds, it's worth asking your representatives, is this new provision something that we can use to help solve the problems that we're experiencing or we will experience in the future. Another point to pick out that's not on the slide there is around retrospective application of the new law. So we're often asked, we have a case now, what can we do about it after May the 1st? Will the law be retrospectively applied onto those cases that occurred beforehand? The answer to that is that it shouldn't be. Under the Chinese legal system, the general principle is that the new legislation should only apply to cases that happen after the date of implementation. However, there's always a lot of room for interpretation underneath the high-level legislation, so we will be also watching out for a sort of general culture shift within the organizations that work in the Chinese trademark system, but it should not feature a retrospective application of the new measures. And then the final point I'd like to pick out is that the new law does feature some increased penalties for infringement, and this is aimed at providing a greater deterrent, we believe, by the Chinese authorities, and the penalties were even increased at the very last stage. So by the National People's Congress, when they passed the law, they increased the penalties again up to 3 million renminbi, or about a maximum for statutory damages in civil cases of 3 million renminbi, which is about £300,000. But throughout the law, there were various other measures for administrative cases and punitive punishments, which will increase throughout the process. So although there may well still be a long way to go in terms of calculating sort of real compensatory damages in very large cases, it does look like the sort of general average level of damages may well increase as the new law is implemented. So there are a few questions, things to ask your representatives about. Do we stand a better chance in bad faith cases? Are the penalties going up, and is there any likelihood of either retrospective implementation of the law or a general shift in the culture and the atmosphere of the offices after the new law comes into force? So please be watching out for this, speak to your attorneys, and please do get in touch with either myself here in the Embassy or the China-Britain Business Council if you feel there is more support and advice that we can give you. Okay, David, are there any more questions?
Yeah, I have a few questions coming from all sorts of different angles, so we'll just field a couple of them. We still have, I think, 85 people online, so what I would say is if you have any questions, I'm just putting up a slide there, please feel free to type them in. We'll deal with a couple now, and if a few more fly in, we'll deal with those too. But also, if we don't get them today, we'll follow up afterwards. I have a question here from Claire. Maybe, Tom, I'll field it to you first, and maybe see if Lindsay wants to jump in afterwards. Claire asks, if applications are required to be made in good faith, does this imply that bad faith oppositions will be taken more seriously, and how high is the standard of proof expected to be?
That is a very good question. So my feeling is that yes, it is a recognition by the drafters of the legislation that there is a problem, not just with preemptive applications for trademarks, by the way, but in China there are also people that are using different parts of the system in ways that could be described as bad faith. So, for example, bad faith oppositions and other sort of bad faith actions. So there is a recognition by the Chinese system that there is a problem here, and yes, I do believe that this is a signal that they do intend to take this more seriously. However, it's very difficult to say at this stage exactly how this will be implemented. So to date, this new provision in the law, although there, has not yet been tied to the opposition process against preemptive marks as being a grounds for successful opposition or for successfully opposing an application. That doesn't mean it can't be used in these situations, and only time will tell before we see exactly how this can help out. And it's pretty impossible right now to answer the question about where the evidence burden will be fixed. But it is a positive sign, and we and many others will be watching very carefully after May the 1st for any indication about how this new provision will help people that are combating preemptive applications.
All right, thank you very much for that. Lindsay, I'm not sure if you have a comment on that question. Anything you'd like to add?
I'd just like to say, like Tom, we're going to wait and see what happens. But it's certainly something that we intend to take advantage of. And I think going back to one of my points in my talk is that if somebody is using your mark in bad faith, particularly if there's somebody who's you previously dealt with or maybe discussed business with, and then they've taken advantage of what you've disclosed to them, this is another case where it's incredibly important to produce evidence and to show in an opposition, the dealings between you and the company, any emails, details of any meetings. It's not just enough to say, oh, they've ripped me off. So that's something that we do intend to make use of this new provision as best we can, and it's something I think we will have to back that up with as much evidence as we can if we're going to be successful.
Lovely, thank you. I've had quite a lot of pinged answers. Somebody must have said something controversial. Concerning the policy behind no rights of appeal for unsuccessful opponents, I've got 3 or 4 questions. Perhaps if you could go through, maybe go in a little bit more depth about how that appeal process would work and any changes that there are and progress that still needs to be made. Tom, over to you.
Sure, I can. And this is, has been a sort of controversy within the amendment process as well. So the way that oppositions happen now and have happened up to this point are that if you spot, so for example, through one of those monitoring services, someone who's made an application for a mark that you want to oppose, you file that opposition with the Chinese Trademark Office. The Chinese Trademark Office then makes a decision on that, and potentially hearing arguments from both sides, so from the applicant and from the opponent. And if, at the present system, if either of those parties disagrees with that decision, they can appeal it up to the second stage, which is the Trademark Review and Adjudication Board, the TRAB, that Lindsay mentioned in his talk as being an organisation which actually gives sort of more reasoned and longer explanations of its decision-making process. Under the new revised law from May 1st, if you are an opponent, so if you're opposing a mark that's been applied for by somebody else, you do not have that automatic right to appeal sort of through to the second stage. And if you lose the opposition, the application will be granted and the mark will go onto the register. So this clearly is reducing the number of opportunities that opponents, people bringing oppositions, will have to have their case heard through the system. And I've spoken with a few companies who were looking at this and wondering, what is the difference, or what should they do? Should they put in these oppositions anyway, or should they wait and make an application for a cancellation of a mark which is already on the register later? Because if you apply for a cancellation of a mark that's already on the register, you do still have those appeal routes open to you, open to both parties through the decision process. So people are looking at this and trying to work out what the best strategy is for them under the new system.
All right, thank you for that. A couple more we'll take. Yeah, I mean, a lot of people have quite a lot of questions on that, but I don't think we'll get to them all today. So we've covered some area on that appeal issue. Question here from Fred. Can you comment on the enhanced protection for prior rights? Lindsay, any thoughts from your side?
I think I'm going to hand that one over to Tom.
Okay.
So there are different ways that you can try to oppose or to combat these preemptive applications potentially made in bad faith. So one of them is potentially into the new law by arguing that they're not in good faith. Another way is to say that, well, this mark cannot be registered because I have a prior right. So I have a trademark or potentially even a copyright in some sort of a stylistic logo, which has already been registered, already been used, has a reputation, so therefore this mark should not be allowed to go onto the register. The way that the new provisions potentially boost protection for prior rights is that they have taken away the requirement that a reputation in China cannot be gained by use outside of China. So they're saying that there are international brands which can build a reputation within China with the Chinese public, even if they do not yet have a sizable market presence within mainland China. So it's a recognition that international reputation does impact on Chinese consumers. And that wasn't something which was there in previous drafts as the law was going through the legislative process. Now, again, this is something which will likely be tested and will be argued on both sides as we see cases coming in from May the 1st. But there has seemed to be a little change in the wording, which many, particularly in European context, are potentially quite significant.
All right, thank you for that. Question here from Giles. Is manufacture of a product solely for export purposes classed as infringing activity? Tom?
I think we have some people who are quite familiar with details of the Chinese trademark system here today. That is something where the Chinese courts are in, should we say, disagreement with each other. There have been rulings,
fantastic!
both sides of it. So it's an area where there's quite a delicate balance at the moment throughout the legal system in China. So some courts have said that yes, manufacturing for export, manufacturing in China solely for export, so goods not entering the commercial channels for Chinese consumers within the Chinese mainland. They said that that is infringement, and other courts have said that that isn't infringement, because their reasoning being that there cannot be any confusion to the Chinese public because it never enters the commercial channels in China. I think the global norm would perhaps be that the process of manufacturing and affixing a mark to a product should constitute use and therefore could potentially constitute infringement, even if those products are not going into the domestic commercial channels. But this is something, say, in China, which is not yet completely fixed, and there are, as you can imagine, given China's sort of manufacturing role in the global economy, voices on both sides of this debate, both within China and indeed globally.
All right. Okay. Well, I think we're kind of drawing towards the close of our session this morning. I do have a lot more questions. Some of them are quite specific. So I think what I'll do for now is probably just take those questions and pass them on to our two speakers. What I would do is maybe close on a general thing that might be helpful for everybody. Keith asks, can you recommend a monitoring service for Chinese trademarks, or indeed, you know, is there a list of good services? Lindsay, maybe you can, being somebody who does it, can you recommend?
We use a company called TMDS, and they provide a very good serve for us. Part of the problem for us is we're not just searching against marks, we're also searching against sort of Scottish words, Glen, Highland, Tartan. So it's quite a sophisticated system. So they've been able to come up with a solution for that. So we've worked with them for a long time. However, I think most trademark agents will either have their own system or work closely with a company that does. And my first suggestion would be to ask your trademark agent for advice. If you're just simply looking to get your mark watched, then there are a number of providers who can do that very well.
It's also worth saying that in reply to that question, that the China-Britain Business Council in China and also the UK office does have a list of IP service providers for use of their members and other British companies. So also get in touch with the CBBC if you're looking to find some people who can help you with that. I'd also like to say here from Beijing, and maybe David, you were going to come on to this just in a moment, but as we have some of these sort of more technical questions we haven't been able to answer, I'm very happy to answer them by email afterwards, but we also have a second webinar which is aimed more at industry professionals, trademark experts, either from the trademark attorney industry or from in-house at companies, people who have a more deeper understanding and would like to go into some of these sort of technical issues in more detail. And that will be the first Wednesday after Easter, I believe, so the 23rd, I think it is, David.
That's correct, yeah.
Yeah. So feel free, and maybe as a follow-up to this session, we can circulate a link to that, and people who do want to dig down into some of these details a bit more are very welcome to join us.
Absolutely, absolutely. Okay, thanks, Tom. Well, firstly, I'd like to say thank you very much to Tom and to Lindsay. I hope this given a flavour for a lot of you out there. Our little system only takes 100 people, so for those of you who couldn't make it today, and if you have colleagues indeed, we do record this session and we do post it onto our website. We'll put the PPT and the recording online, so for anybody who missed it, or if you feel that there's colleagues who should have seen it. So you can see the slide I'm showing right now. just go to our webpage and you see what we do. You'll find on the drop-down at Events and Trade Missions, you'll find a section called Webinars, and you can register for upcoming sessions. And there's a link to past webinars. Actually, Tom has done with the CBBC and myself. We've done 4 previously on different issues like IP infringement at trade fairs and all sorts of different things. You'll also find links to those previous recordings there. The one that Tom was just talking about is the 23rd of April. I think it's probably easiest if I just circulate some information on that to everybody who attended today. It'll probably be useful for you all. So I think that's really it for today. If you did type in a question, our little system records it, so I do have a copy of that question and I will forward it to Tom and to Lindsay. Failing that, really, just thank you very much to both of our speakers. Thank you very much for all of your time. I hope this was useful. If you have any feedback or suggestions, please contact me directly, be it for this session or perhaps you feel there might be other topics that are suitable to this platform, or maybe yourself you feel like you'd like to do one with us. That's really it for today. So thank you very much for your time and have a great day. Bye now.